Extent of power to share information by ED under PMLA. Preface. Enforcement Directorate, ED, while conducting investigation under the Prevention of Money Laundering Act, 2002, PMLA, may collect confidential information. If this information reveals that any laws other than the PMLA have been violated, the ED may share that information with the concerned government authorities. This power is given under Section 66 of the PMLA, subject to some terms and conditions. When information can be shared. Enforcement Directorate, ED, while conducting investigation, information may be shared upon request of any of the agencies or on its own initiative by the ED. If the ED considers that it would be necessary to enable the agency to perform its functions under the law, it can share information with specified agencies under Section 66(1) without forming any opinion about any contravention. On the other hand, if the ED is of the clear opinion that any law has been violated, it may share the information with any concerned government agency subject to forming an opinion of such violation under Section 66(2). With whom the information can be shared. The ED can share information with 25 specified government agencies under Section 66(1) for regular, suspected, inconclusive purposes under any law. The specified agencies include bodies responsible for enforcing tax laws, foreign exchange laws, and anti-narcotics or drugs laws, National Investigating Agency, Serious Fraud Investigation Office, state police departments etc. However, the central government may gazette notify other agencies for obtaining such information. On the other hand, if the ED is of the clear opinion that any law has been violated, it is empowered under Section 66(2) to share the information with any government agency concerned with such law. Duties of recipient agencies afterwards. Upon receipt of the information, the receiving agency shall proceed in accordance with the law governing such agency. They are not bound to agree with the findings of the ED. Judicial precedents suggest that the findings of the ED do not add any evidentiary value to proceedings under any law other than the PMLA. Those are mere assumptions, based on which no action can be taken. Therefore, the receiving agency must conduct its own investigation, apply its own mind to the information received and other documents in the case and arrive at its own conclusion before taking any action. Can ED intervene afterwards? After information is shared by ED, recipient agencies are under no obligation to provide feedback or share their findings with them. Any such obligation would amount to an interference with their independent activities. Moreover, any further intervention by the ED would be irrelevant as they are neither specialized in nor enforce such other laws concerned. Furthermore, if the information shared by the ED resulted in any investigation by the recipient agency, the progress and results of such investigation shall be precluded from being shared with any person or government agency, including the ED, for the protection given under the Right to Information Act, 2005. Any questions? Ask C-Quel.